Assalamu alaikum. Good afternoon, dear students. This is Dr. Noor Huda Golia to present the course Digital Law and Regulations for master students on digital transformation and innovation. This is the third chapter under the title Digital Law and Regulation. Alright, dear students, our course is going to be outlined as follows. Number one, it's going to be the law, and we're going to introduce some basic concepts. The second one is going to cover digital law and regulation. The third one is going to be about internet law. And the last one, but not the least, it's going to be about the law of software. So let's start with the first element, law, some basic concepts. Definition. Law can be defined as a system of rules and guidelines that are enforced through social institutions to govern behavior. It shapes politics, economics, and society in various ways and serves as a primary social mediator of relations between people. Heading now to types of law, we have two types, objective and subjective law. Number one, objective law. Objective law refers to the body of legal principles and rules that exist independently of individual beliefs and opinions. It encompasses the set of laws and regulations established by governing authorities and applicable to everyone within a particular jurisdiction. Objective law is impartial and based on societal norms and legal statutes. Subjective law. Subjective law pertains to the individual's personal understanding and interpretation of their legal rights and obligations. It reflects the perception and beliefs of individuals regarding their rights, often influenced by their personal experiences, values, and cultural backgrounds. Subjective law is shaped by the individual's perspective on their legal rights and responsibilities within a specific legal framework. So let's get into some details about objective and subjective law. Objective law is a set of legal rules, like for example, constitution, international treaties, laws, or regulations. It applies to everyone in the same way, ensuring equality among all citizens. That is to say, the rules of objective law are formulated in a general and impersonal manner. However, when we talk about subjective rights, it stems from objective law, that is the legal framework, which are no more than privileges granted to an individual to benefit from an object, a value, or a relationship with another. For example, let us give some examples for the subjective law. We have the right to property, the right to marriage, and for example, the right to one's image copyright. Here, the subjective law is the individual right of each person to arises from a legal fact or a legal act. Alright, dear students, let's move to an example as a case here, Mr. Muhammad, about the objective and subjective law. So, Mr. Muhammad has bought a Fiat in this situation, and here, Mr. Muhammad's choice has been given as Fiat. So, in here, the situation is a subjective law. Yet, if we are talking about the highway and the speed on the highway, it's limited to 120 kilometers per hour, which is an objective law. In the case, if he increases the speed more than 120, he's going to get punished because it's out of law. Let's go to an automobile to travel on public roads must be registered in the name of its owner and must be equipped with a circulation permit and license plate. In this situation, it's going to be an objective law. Let me draw your attention, dear students, that when we are talking in French with the word droit, if it is capitalized or used with a big D, it introduces the objective law. Yet, if we use it with a small d, which means not capitalized letter, it's going to be the subjective law. Alright, let me introduce another classification of law. The first definition is going to be about public law. Public law regulates the relation between individuals and the government. Let's take some examples. For example, the international law, the administrative law, constitutional law, criminal law, and tax law. The second type is going to be the private law that governs relationships between individuals. For example, we have contract law, the tort law, family law, employment law, land law, and finally the commercial law. So, fundamentally, law in general is classified into public and private law. With the evolution of society also appear the so-called social law. It seeks to cover all the law that is associated with human rights. Social law, rather than starting from the point of equality of man, seeks it as an aspiration to do this. It regulates the elements to try to level human beings or seeks to balance inequalities in relationships. Among the branches of law found in this classification are the following: labor law, which means when not considered part of private law; immigration law; agrarian law; and law related to social security. Okay, dear students, let's move to legislations and lawsuits. So, legislations and lawsuits are two important components of the legal system that play distinct yet interconnected roles in upholding the rule of law and ensuring justice. Legislations. Do know that I have used some Arabic terms in order to clarify the ideas for you and not get misleaded. So, number one, legislations. Creating laws. Legislations typically passed by a legislative body and responsible for creating, amending, and repealing laws that govern various aspects of society. These laws can cover a wide range of areas, including civil rights, criminal justice, business regulations, environmental protection, and more. Regulating conduct. Legislations provide guidelines and rules that individuals, organizations, and government entities must adhere to. They are designed to maintain order, protect rights, and promote the welfare of society as a whole. Establishing frameworks. Legislations set the framework for the functioning of the legal system and provide the structure for the administration of justice. They define the procedures for enforcing laws and resolving disputes. Okay, dear students, after covering legislations, we need to move to lawsuit. So lawsuits, number one, we're going to cover dispute resolution. Lawsuits or legal actions are formal proceedings initiated by parties seeking resolution for a specific legal dispute or grievance. They provide a platform for individuals or entities to seek justice and remedy for perceived legal wrongs. Enforcing rights. Lawsuits are instrumental in enforcing legal rights and obligations. They allow individuals to assert their legal claim, defend against allegation, and seek legal redress for any harm or injury suffered. Number three, interpreting laws. Lawsuits often involve the interpretation and application of existing laws to specific cases. Courts examine the relevant legislations, legal precedent, and arguments presented by both parties to arrive at a fair and just decision. Okay, let's move to digital law and regulation. While the internet and other information technologies are bringing enormous benefits to society, they also provide new opportunities for criminal behavior. Alright, since the early 1980s, competition has gradually been introduced in the telecommunications market, first in the UK in 1982 for regulating the market of cellular mobile communications. In the rest of Europe, mobile communications were opened for competition in 1992. Also in 1998, all telecommunications in Europe were demonopolized and opened for general competition. This development and the extensive use of the internet have generated a demand for regulating the telecommunication market to make it a level playing field. So let's get started with the definition of the digital regulation. Regulation of the ICT market is the intervention of governmental, legal, social, economic, or technological authorities by rules or procedures to restrict the freedom of operations for market participants, in particular mobile operators, internet service providers, and application service providers, and to target the evolution of the market. The regulations apply to: first, fixed and mobile network operators; second, user access providers; third, internet service providers; application service providers; and the last, content providers. Okay, so what are the motives for regulation? There are several motives for regulation. First of all, to avoid market failures such as formation of monopolies, also to foster fair competition. Another one is to secure that the users have correct and adequate information about the market. Again, to ensure the affordable access to the ICT infrastructure, thereby satisfying collective needs of the public. To protect individuals against unethical business conduct and abuse of personal data. To promote professional and ethical conduct of market participants. To stimulate peer-based service innovation and development of new technology. Alright, Internet regulations. Regulating the Internet may be not only done by laws and legal frameworks. The pathetic dot theory developed by Lawrence Lessig defines four modalities of regulation. First of all, we have legal, second, we have market, the third one, technologies, and the last but not the least, society. Alright, let's try to explain Lessig's four modalities of regulation through this diagram. First of all, we have legal. It answers the question how the legal framework in a jurisdiction is used to regulate. The second one is market. It answers the question how trade markets and economic factors are used to regulate. Number three is society, how norms and societal factors are used to regulate. And the last one, it answers the question how technology is used to regulate. Alright, dear students, let's talk about Internet regulation and give an example for the four previous modalities applied to the music industry. Note that one key problem in this industry is the violation of copyright and illegal downloading and spreading of the music on the Internet. Lessig's modalities has been employed to regulate this issue. Regulation by legal measures. In many countries, downloading copyrighted material is illegal by law. People downloading and sharing such material may be prosecuted and punished according to the laws in their jurisdiction. Regulation by market. In 2000, new services offering access to copyrighted media were launched like Spotify, iTunes, and Tidal. These services created a market for legal access to music and contributed to regulating the market. Number three, regulating by technologies. The 2000s also saw the emergence of technological copyright protection of music and other media by which copying a specific CD or a DVD was not possible. Number four, regulation by society. In spite of the laws passed to regulate privacy, people still in huge numbers continued to download and spread copyrighted material illegally. This was because the general opinion of the public was not a view free music downloading as a crime that should be punished. Public opinion is a weak regulating force. Alright, dear students, do you know that at the beginning of this chapter we've already discussed the general law in general, but now specifically we're going to talk about digital law. Digital law refers to the legal framework that governs the use, access, and protection of digital information, technologies, and networks. It encompasses a wide range of legal principles and regulations that aim to address the unique challenges and issues arising from the use of digital technologies, including the Internet, social media, e-commerce, and electronic communication. Right, dear students, let's talk about areas of digital law and give you some examples. For example, in cybersecurity and data protection, intellectual property, e-commerce and online contracts, internet governance and regulation, cybercrime and online misconduct, and the last but not the least, the law of software. Now we're trying to give you some examples through breaking digital law. For example, we have hacking and unauthorized access, cyberbullying and online harassment, copyright infringement and piracy, cyber fraud and scams, data breaches and privacy violation. Okay, The consequences of breaking digital law, for example, legal penalties, civil lawsuits, criminal prosecution, loss of reputation and trust, restrictions and sanctions. Okay, in this part, Internet law was covered by the United Nations. So, the United Nations Declaration on Human Rights, promulgated by the UN in 1948, articulates the fundamental rights that every human being is inherently entitled to by virtue of their humanity. Particularly relevant to Internet law are the following key elements. So the preamble of the declaration, especially the second paragraph, emphasizes that human beings have the right to freedom of speech and belief. It also underscores in the third paragraph that human rights should be protected by the rules of law. Member states have committed to working with the United Nations to promote universal respect for adherence to human rights and fundamental freedom. Article 12 of the Declaration affirms the protection of privacy, stating that no one should be subjected to arbitrary interference with their privacy, family, home, or correspondence, and that everyone has the right to legal protection against such interference or attacks on their honor and reputation. Article 19 is particularly pertinent to Internet usage, as it asserts that everyone has the right to freedom of opinion and expression. This right includes the freedom to hold opinions without interference and to seek, receive, and disseminate information and ideas through any media regardless of frontiers. In summary, the United Nations Declaration on Human Rights upholds fundamental principles that have direct implications for how human rights are protected and respected in the digital age, including the realm of the Internet. These principles underscore the importance of freedom of speech, privacy, and the right to access and share information, all of which are integral to Internet law and governance. It is certainly true that the Internet has the potential to fulfill and enhance the right to cultural life asserted in Article 1, which states, "Everyone has the right to participate in the cultural life of the community, to enjoy the arts, and to share in scientific advancement and its benefits." Although this Universal Declaration of Human Rights is not legally binding, all 199 members of the UN have agreed to it because it is intrinsic document for membership to the UN. In addition, 150 countries have ratified and signed the International Bill of Human Rights, which consists of the Universal Declaration of Human Rights and two other international treaties. Number 1, the International Covenant on Civil and Political Rights in 1996, the International Covenant on Economic, Social, and Cultural Rights in 1966. So, understanding Internet law is essential for individuals, business, and organizations that operate online to ensure compliance with legal requirements and to protect their rights and interests in the digital space. As the Internet continues to evolve, Internet law will continue to adapt to address emerging legal challenges and technological advancement in the online environment. So, Internet law areas, we have online freedom and expression, e-commerce and online transactions, cybersecurity and data privacy, intellectual property protection, and cybercrime and online misconduct.